Students, the rules regarding guardianship under Mohammedan law. So, here what are all the customary rules? What are all the present rules? So, what are all the what you call classical rules? What are all the statutory rules? We can discuss in this video. So, here with regard to the guardianship, here law prescribes certain age limit before which a person is said to be a minor. That means here law prescribes certain age limit for a minor in order to become a major. That means here it depends upon the law. Here a minor has no capacity to understand the legal consequences of his her activities. That's why he will be called as a minor. So he doesn't have a capacity to understand the consequences of his activities, his or her activities. The legal position of a person who has not attained the age of so prescribed is called minority. That means when a person who has not attained the prescribed age, he will be called as a minor, or he can be called as he is under the minority. The legal position of a minor who has attained the age is called the age of majority. That means if the person attained the age, he will be called as a major, or he has attained the age of majority. Under Muslim law, the age of majority is regulated by two systems, that is classical Muslim law and the statutory law. So under Muslim law, with regard to this age factor, there are two law are there. That means two classification of the law is there. That is, one is classic Muslim law and the statutory law. Under classical Muslim law, a person is said to be a minor if he or she has not attained the age of puberty. That means what has been mentioned in the classical Muslim law, that with regard to the age, one who has not attained the age of puberty, he can be called as a minor. That means the age of puberty is 15 years as in the classical Muslim law. Here, with regard to the, but as already discussed, 15 years is the age of majority only for marriage, dower and divorce. So this aspect with regard to the age of puberty or age of minority can be taken into account with regard to the aspect of the marriage, dower and divorce. That means with regard to the three aspects, that is the marriage, dower and divorce, the age factor of age of puberty or age of, that means one who has attained the age of puberty can be called as a major. So with regard to that age of puberty will be taken into account with regard to the aspects of marriage, dower and divorce. Thus, for purposes of marriage, dower and divorce, a Muslim who is not attained the age of puberty is called a minor. Here, which is that means the deciding factor is that one who has not attained the age of puberty is called as a minor under the classic Muslim law. But what is the stand in the statutory law? That is, under the statutory rules which regulate the age of majority of the Muslims who are given below. So here with regard to the statutory rules, there are certain requirements has to be meted out. So which are those requirements? Let us see. For purposes other than marriage, that is dower and divorce, the age of majority is governed by the Indian Majority Act of 1875. So except dower and divorce, for the purpose of other than the marriage, divorce and the dower, the age of majority is governed by the Indian Majority Act of 1875. So under this act, the age of majority is 18 years. A Muslim who has not attained the age of 18 years is a minor in respect of all matters except marriage, dower and divorce. That means under this Indian Majority Act of 1875, it has been prescribed that except marriage, dower and divorce, the age of a Muslim has been taken as 18 years only for the purposes other than this marriage, dower and the divorce. So second aspect is where a Muslim is within the supervision of a guardian appointed by a court of law. So here what we are discussing with regard to the statutory rules which prescribes the age of majority. So here where a Muslim is within the supervision of a guardian appointed by a court of law, or a Muslim whose property has been under the supervision of court of wards, the age of majority for such Muslim is 21 years. Therefore, except in matters of marriage, dower and divorce, the age has been fixed by the court of law is 21 years for the purpose of property. So that means here where a Muslim is within the supervision of a guardian appointed by the court of law, or a Muslim whose property has been under the supervision of court of wards. That means here two things we have to see. That means when the Muslim is under the supervision of a guardian, that means here suppose a minor person is there to look over his interest, to look over the aspects concerning to his person, his property. It may be anything. That means if any guardian is appointed by the court of law and a Muslim whose property has been under the supervision of the court of wards, here the year which is the age of majority means the age of majority is 21 years for the purpose of which will deal with regard to the aspects of a person who is under the custody of some person who has been appointed by the court of law, and a person whose property has been under the supervision under the court of wards. So under such circumstances, the age of majority of a Muslim has been prescribed for 21 years. And next aspect is for purpose of marriage, dower and divorce, a Muslim becomes adult after attaining the age of puberty, that is 15 years. But for filing a suit in court of law, the minimum age is 18 years, not 15 years, even if the suit may relate to marriage, dower and divorce. So one interesting aspect is that, so with regard to the marriage, dower and divorce, if the Muslim attains the age of puberty, that is 15 years, that will be taken into account. But with regard to any filing of the cases or suit in the court of law with regard to the marriage, dower and divorce, it is necessary that the Muslim male person or Muslim female person, he should have attained the age of 18 years, not 15 years. So even if the suit may relate to marriage, dower and divorce, the result is that a Muslim under the age of 18 years is a minor and cannot file a suit relating to his or her marriage regarding dower and divorce without the next friend. That means the next friend, he may assist him even though he is under the age of 18 years with regard to the marriage, dower and divorce. So let us see the classifications of guardian with regard to which are all the persons who can act as the guardians under the Muslim law. So here under Muslim law, there are four kinds of guardians we can see. Here Muslim law recognizes the following kinds of guardians. That is, first one is natural or legal guardian. Second one is testamentary guardian. Third one is guardian appointed by the court or statutory guardian, and de facto guardian. So let us see what are all the things concerning to the classification of guardians. Let us see. First we can go to the natural guardians. Natural guardian is a person who has a legal right to control and supervise the activities of a child. That means natural means the person who has given birth. So such person has a legal right to control the supervise the activities of a child. It is normal, natural. And father is recognized as the natural guardian of his child under all the schools of Muslim law. That means, as you know, there are Sunni law is there, Shia law is there, and sub sects are there. So whatever it may be there, here in under all these schools, father is recognized as the natural guardian of the child under all the schools of Muslim law. Here, the father's right to act as guardian of the minor is an independent right and is given to him under the substantive law of Islam. That means, under the substantive law of Islam, the father gets the right over the child. That means, it is a independent right. That means, nobody can question this sort of the right. Here, the natural guardian is called the de jure or the legal guardian. That means, this natural guardian is also called as the de jure or legal guardian. So this is very much important. That means legal means that is in fact that can be called as a de jure guardian only. And as stated above, only father is the natural or legal guardian of his child. But in the absence of the father, who will come the next person is the father's executor. In the absence of the father executor will come into the shoes of the father, and he may act as the legal guardian. And executor is a person who is appointed by father or grandfather to act as a guardian of his minor child on his behalf. That means here certain gradation has been given. That is father, executor of the father, paternal grandfather, executor of the paternal grandfather. That means who is a executor? Executor is a person who is appointed by a father or grandfather to act as the guardian of his minor child. So that means here, if the father is there, he will appoint the executor of the he will appoint the executor. And if he is not there, paternal grandfather, and paternal grandfather, he may also appoint the executor. So this is the aspect we have to appreciate. And next one is paternal grandfather or paternal grandfather's executor acts as legal guardian. So this is the law with regard to the natural guardian. That means who will be the natural guardian means father. In his absence, or he may appoint his executor to act as the natural guardian of his child. In the absence of the father and the executor, paternal grandfather. Paternal grandfather can also appoint the executor. Thus, the natural or legal guardian of a minor in order of priority are as under. So, this is the priority which has been given: father, executor of father, paternal grandfather, executor of the paternal grandfather. Then under Muslim law, in the absence of any of the above mentioned persons, nobody else is recognized as the natural or legal guardian of a minor. See the appreciation of the under Muslim law. That is, if under these under these aspects, gradation, father, executor of the father, paternal grandfather, executor of the paternal grandfather is not available, then nobody else will be recognized as the natural or legal guardian of a minor. So what is the stand under the Shia law? So according to Shia law, in the absence of the father, only paternal grandfather may act as natural or legal guardian. So that means under Shia law, in the absence of father, who will be there? That is paternal grandfather. He will act as the natural or legal guardian. That means father's father is known as paternal grandfather. Thus, in the presence of paternal grandfather, the father's executor has no right to act as legal guardian of the child. So, this is also very much important with regard to the Shia law. Suppose if the paternal grandfather is there, at that time, then the father executor doesn't have the right over the legal guardian of the child. That means if paternal grandfather is alive, he subsists, he exists, at that time, the father's executor doesn't have the right over the paternal grandfather. So this is this aspect under the Sharia law. Let us go to the testamentary guardian. Who can be called as the testamentary guardian, and what is the law with regard to the testamentary guardian? Testamentary guardian is a person who is appointed as guardian of a minor under a will only. That means the name itself says testamentary. That means a person appointed as the guardian of a minor through a will. That means it has been written in a will. That means after his death, so and so person will become the guardian of a child. So that can be called as a testamentary guardian. That means only father or in his absence, paternal grandfather has right to appoint a testamentary guardian. So this is a very much important thing. That means who can appoint the testamentary guardian means only the father and the paternal grandfather only, not the other grandfather. Only a paternal grandfather has got the right to appoint the testamentary guardian. And with regard to the no special formality is required for the appointment of a testamentary guardian, but as is obvious, such a testamentary guardian must be competent to act as guardian. So what we have to see, what are all the formalities has to be followed means no formality has to be followed with regard to the appointment of the testamentary guardian. That is to say, he should be an adult, sane person, a non-Muslim, and a female may also be appointed as a testamentary guardian. That means who can be appointed as the testamentary guardian means any person. If he is an adult, if he is sane person, then he has got the qualification to get appointed as the testamentary guardian of a Muslim child. That means a non-Muslim can also, a female can also be appointed as the testamentary guardian. But with regard to the Sharia law, a non-Muslim cannot be appointed as the testamentary guardian. That is the thing we have to see with regard to the Sharia law. That means when we see certain aspects with regard to the with regard to all the Muslim rules, there may be certain what we call certain differences are there with regard to Sharia law, Hanafi law, like that. So with regard to those things, we have to concentrate with regard to the certain what we call the aspects. Then we can go to the aspect of guardians appointed by the court. So when the guardians can be appointed by the court. So far we have seen the natural guardian, we have seen, then we have seen the testamentary guardian. Next we have to see the guardians appointed by the court. Then we have to look into the de facto guardians. These are all the classification of the guardians. So let us see the aspects concerning to the guardians appointed by the court. In the absence of a natural and testamentary guardian, that means in the absence of the natural and testamentary guardian, the court is empowered to appoint a guardian for the protection of the minor's person or property or for both. That means when the court can appoint the guardian. So here when there is no natural guardian, when there is no the testamentary guardian, then the court can appoint the guardian for the protection of the minor's person and the property. That means for the both also the court can appoint. Here the appointment of the guardian by court is governed by the Guardian and Wards Act of 1890. So with regard to the appointment of the guardians by court is governed by the Guardian and Wards Act of 1880, which is applicable to all the Indians irrespective of their religion. In India, the courts appoint the guardians for minors, person or property under this statute. That means here, irrespective of the religion, under the Guardians and Wards Act of 1890, the courts can appoint the guardians for the person or the property. Therefore, such guardians are also called the statutory guardians. So, when the guardians has been appointed under the Guardians and Wards Act of 1890 by the courts, so it can be said that they are the statutory guardians. That means they have been appointed under the statute. That means the provisions has been given under the the Guardian and Wards Act of 1890. It may be noted that no provision has been made under this Act for the guardianship for marriage. For under this Act, there are no provisions concerning to the marriage. So, other than this one, that is a person and the property, the guardian will be appointed. The result is that except the guardians for marriage, the guardians for a Muslim minor, person or property may be appointed by a court of law. So this aspect we have discussed. In such cases, there may be conflict between the Muslim personal law and Guardians and Wards Act. So in that event, there may be some what you call differences will be there on the Muslim law and the Guardians and the Wards Act. But which act will prevail means the Guardian and Ward Act only which will prevail. Here court means the court of the district judge. Here the courts are empowered to appoint the guardians for a minor upon an application. Such application may be made by any of the following persons. That means who can make the application to get appointed as the guardians under the Guardianship and Wards Act means here here there is a mentioning or there who can make the application means under 1, 2, 3, 4, 5 under 5 headings the persons who are all the persons who can claim to be appointed as the guardians has been given in this table. That is any person desires of being or claiming to be the guardian of the minor. That means any person who has got the interest in bringing up the child, they can make the application or to get appointed as the guardian. And second aspect is any relative or friend of the minor. Any relative of the friend or of the minor can also make the application. Friend or the relative. Third aspect is the collector of the district in which the minor is generally resides. Even the collector can also, he can make application, he can act as the guardian of the child. If the court is satisfied that it is for the welfare of the minor that an order should be made, then it make an order. That means appointing a guardian of minor's person or property or both, or declaring a person to be such guardian. Then we can go to the next aspect, that is de facto guardian. That is who will be called as the de facto guardian. Here a de facto guardian is a person who is neither a legal guardian nor a testamentary guardian nor statutory guardian, but has himself assumed the custody and case of a child. That means what happens, certain things with regard to the protection of a child. Certain persons, they voluntarily they will come and take the risk of bringing up the minor child. So at that time, such guardians can be called as the de facto guardians. That means they have been not appointed by the natural guardian, not appointed under the testamentary guardian, not appointed under the guard and Warship Act, but they themselves has taken the initiation with regard to the protecting the child. So according to TecH, that is under the Muslim law, according to the Muslim scholar, a de facto guardian means an unauthorized person who as a matter of fact, that means de facto has custody of the person of a minor of his property. It may be said that a de facto guardian is a person having no authority for the guardianship, but under the circumstances has taken place the responsibility to act as the guardian of a minor. That means according to TecH, this de facto guardian can be called as the unauthorized person. But as the circumstances invites, such guardians will spring into action to protect the children. So far we have seen the law concerning to the guardianship, and we have seen the classification of the guardian. Then we can go to the powers and functions of the guardians. Here, what are all the powers are there with regard to the guardians? So here we have to see what are all the powers concerning with regard to the guardians. So first of all, we have to see the powers and functions of the guardians in respect of the minor's property and for marriage are different. That means concerning to the the minor's property for marriage and with regard to the property, the powers and functions of the guardians will differ. So, therefore, the powers and functions of the guardians are discussed in the following lines separately in respect of the person of a minor, the property of a minor, the marriage of a minor. That means here the powers and functions of the guardian are not similar. So that's why there is some separate distinction has been made with regard to the person of a minor, the property of a minor, the marriage of a minor. Here, what are all the powers and what are all the functions of the guardian with regard to the aspects concerning to the person of a minor, the property of a minor, the marriage of a minor. So let us see what are all the aspects will come under the person of a minor, and what we can see under the property of a minor, and what are all the things concerning to the marriage of a minor. So let's first of all we can see the guardianship of the person. That means here we are looking into the person of a minor, that is concerning to the guardianship. Here guardianship of the minor's person means an overall supervision of the minor's personality. That means guardianship of the minor's person means it is a overall supervision of the minor's personality. That means it is a omnipotent clause, we can say. That means it is concerning to the overall supervision of the minor's personality. It means the care and welfare of the child, including the liability to maintain it. It's more than simply the custody of the child up to a certain age. Under Muslim law, guardianship of the minor's person is called wiliyat-e-nafs, and the custody of the minor is called the izanat. That means here, with regard to the guardianship of the minor, it is a very broad aspect. That means it will be up to a certain age, and this aspect can be called as with regard to the person will be called as wiliyat-e-nafs, and this aspect of the custody of the minor, that means can be called as a izanat. That means they are sometimes taken to mean the same thing, but under Muslim law, the two aspects of the guardianship are different and governed by the distinct rules. This should be the distinct rules. And the guardianship of the child's person means overall supervision of the child during its minority. That means, as we have said, what is meant by guardianship of the person means, that means it is concerning to the overall supervision of the child during its minority. Father or his executor, or in absence the paternal grandfather, being the natural guardian, are in charge of the minors, the person. That means who are in charge of this aspect means, that means the father, or in his absence the paternal grandfather, being the natural guardian, are in charge of the minor's person. That means they can become the guardian of the person. On the other hand, custody of the child izanat simply means a physical possession, custody of the child up to a certain age. Although mother is not natural guardian under Muslim law, but she has a right to the custody of her child till the child attains the specific age, but father or the paternal grandfather has a control over the person of the minor during the whole period of minority. So under Muslim law, hence a mother, she is not considered as the natural guardian, but she has got the right over the custody of the child, that is izanat. That is, let us see what are all the aspects will come under with regard to the mother's right of custody, that is izanat of the child. So under all the schools of Muslim law, the general rule is that mother is entitled to the custody, that is izanat, or the physical possession of her child up to certain age. That means even though she is not the natural guardian, but she has got the right of a custody of the child, that will be called as izanat. This rule is based on the presumption that on account of her peculiar relationship with the child, she is obviously the best person to give the natural love and affection which a child requires during its infancy, including its dependence for feeding. Nature itself has given to the mother the custody of her child's embryo even before it comes in the worldly existence. So these are all the aspects, justifications with regard to the giving the child with regard to the explaining the concept with regard to the Isanath. So why the mother has got the better rights other than the other person. Where the child is a son, the mother is entitled to his custody till he attains the age of 7 years. And with regard to the daughter, the mother's right to the custody, which will continue up to the age of puberty, that is 15 years. That means here with regard to the Isanath, the mother of a child, that is which age the mother has got the custody of the child, the right to of custody of a child means up to 7 years she has got the right over the male person, that is a son. With regard to the daughter, up to the age of puberty she has got the right over the girl child. So it may be noted that mother is entitled to the custody of her child under the age of 7 years or the below puberty, as the case may be, even if she has been divorced by the husband or has become the widow, provided she remains unmarried. That means even if she becomes divorced by the husband also, she gets the right over the child. If the male child is 7 years, if the female child is 15 years, even though she has been given divorce by her husband and or has become widow, provided she remains unmarried. That means even if she suppose the Muslim wife becomes widow also, this right will not vanish away. So here with regard to this aspect, there is one beautiful case law is there, that is yes, Rihan Fatima versus Sayyid Bidunuddin Parvez. Here the dispute was regarding the custody of the child aged 3 years 6 months. The Andhra Pradesh High Court held that under Muslim law, the mother rights to the custody of the child, her child, continues even after the dissolution of her marriage by talaq. The court observed that further that in the absence of any other alternate arrangements under the Guardian and Wards Act, to her right to the custody of the child continues even after the divorce. That means in this case law, the Andhra Pradesh High Court has held that the mother has got the better right, and under the Guardians and Wards Act also she has got the preference over the other persons. So then we have to consider with regard to the Isnat, with regard to the father's right of the custody of a child. That is also Isnat. That means the custody of the child can also be called as the Isnat. So here father is entitled to the custody of the following two stages of the child's minority. So in the earlier instance, we have discussed with regard to the mother's right, but with regard to the in this aspect, we are going to consider with regard to the father's right of custody of a child. That means here what are all the things concerning to the father's right of a child. So here there has been two stages has been given. That is, in respect of a minor boy under the age of 7 years and a girl under a puberty, the father is entitled to the custody of the child only in the absence of or disqualification of mother and other female relations of the child. That means, in respect of a minor boy under the age of 7 years and a girl under the puberty, the father is entitled to the custody of the child only in the absence or disqualification of the mother and other female relations of the child. That means, suppose the mother has been disqualified or she has been prevented for certain aspect. That means with regard to any aspect of such, that means a disqualification of the mother, except that one, the father will get the right, even though the child is under 7 years and the girl child with regard to the when it is not attained the age of the puberty, that is 15 years. That means except this one, the mother has got the right. That means when there is a disqualification of mother, then at that time the father will get the custody of the child. That means in respect of the boy over the age of 7 years and unmarried girl over the age of puberty, the father is entitled to the custody of the child as natural guardian till the child becomes adult. That means the next aspect is that after the age of 7 years, who will become who will have got the right over the custody of the child means the father. After 7 years, with regard to the male child, with regard to the female child, after the age of puberty, the father has got the right of custody over the child. Here, the minority of the child for purpose of its custody by father is divided in two stages. The first stage of the minority is up to the age of 7 years in the case of the male child, and up to puberty where the child is female. The second stage begins after the age of 7 years till the age of 18 years in case of a male, and after puberty up to 18 years in the case of the female child, provided she remains unmarried. So, during the first stage, the custody primarily belongs to the mother, and during the second stage, it belongs to the father. Thus, father is entitled to the custody of a minor child in two circumstances. So, these are all the things we have to see. That means, here we have to see, that means when the father will get the right over the child. That means, it will begin after 7 years till the age of 18 years in case of male, and after puberty up to 18 years in the case of female child. So, if she has not been married, if she has been married, the father will not get the right. If she remains unmarried, the father will get the right over the child. So, first, where the child is within the age limit in which mother or female relations are legally authorized to have the custody, but they are either disqualified or not available. Secondly, after the age limit beyond which the mother or father female relations have no right of the custody of the child. So these are all the concepts we have to see with regard to the custody of the child, and with regard to the aspects concerning to the aspect of the aspect of the guardianship for marriage, and with regard to the guardianship of the property. These aspects will be discussed in the next video. So these are all the today we have discussed with regard to the aspects concerning to the what are the rules concerning to the guardianship. That is, we have discussed with regard to the classical Muslim law and the statutory law, and we have discussed with regard to the classification of guardians, that is natural, testamentary, guardians appointed by the court, and the de facto guardian. We have seen these guardians, and we have also seen the powers and functions of the guardians, under which we have seen the guardianship of the person, and the mother's right of the custody of the child, and the father's right of the custody of the child, and we have concluded to this extent. In the next video, let us see what are all the concepts concerning to the guardianship for marriage, and with regard to the guardianship of the property. That means there are three aspects are there. One is guardianship for person, marriage, and the property. Now we have considered only with regard to the person, that is guardianship of the person, and custody of the child with regard to the reason of the mother, and custody of the child, that is a right to custody of the father. So these two aspects has been considered under this video with regard to the powers and functions of the guardians. In the next class, in the next video, let us discuss with regard to the aspect of the property of a minor and marriage of a minor. So this is with regard to the today's video.